What you are about to see here on the left-hand side of the screen is a judge of the United States District Court in Iowa that's about to hear a motion for summary judgment. I gather is what I read from the heading on the Administration Office of the Courts, U.S. Courts in Washington, D.C. of one of these courts, this particular court, one of 14, that has been using video in addition to a court reporter or audio recording, videotaping the civil hearings. And that might be expanded into the criminal arena as well at some point. This is in case number 1CV00142. And when I get this started, let's just pretend this is a U.S. bankruptcy court matter. And that's all legal argument. Very rarely is it Q&A. But what you will see as soon as I start the voice, by capturing the full screen, the video on the left and the text, you'll hear the voices, and as the voices are speaking, one at a time, the text will come up on the screen in real time, with sometimes a little pause, and then it'll burst out with more of the text. There will be no punctuation. There's absolutely no formatting. It's just one long string of text, but it's certainly very readable. Now, what we're doing here at AMVSR LLC is producing very quickly the working rough draft for lawyers and their clients to use immediately, or as soon as we get a audio or video like you're seeing now, and you'll be able to because we have synchronized, after this process, we'll be synchronizing each line of text that you see coming up on the screen to its audio or video companion, and that you can play on any smart device, including your PC and Mac computers back at home or at the office. So that gives you 100% confidence in the record, even though you're going to see mistakes and bloopers, things that are kind of silly. But as the technology gets better and better, audio, automated speech recognition, you'll understand that when we can deliver this kind of a product to the parties who might be able to negotiate a settlement just on what you're about to see, that's synchronized, you might decide to say, we don't need a certified final transcript. We've been able to review that record, play it on our iPhones, Androids, tablets, and negotiate with each other's offices, appellate divisions, narrow the issues, and settle the case without going to a greater expense. And I think that's what Chief Justice John Roberts has been saying all along, that too many Americans are paying too much for services. So let's get started.
I will caution you at the start, this isn't a suggestion I need to have a different judge in the case, but when I was in college, I worked at an assembly facility, a bakery, where we baked mostly high volume production of bread and rolls. Ever heard of Old Home? That was where I worked all those years in Sioux City. And I know a lot about donning and doffing and walking from place to place. Naturally, at the bakery, I had to be pristine, clean. And thereafter, for the 19 years I practiced law, which I was reminded of last night when the judge who's still now 50 years a judge, was my judge, I had a number of cases involving the Sioux City slaughterhouses, including Swift, Armour, Cudahy, and the newer facilities, including Iowa Beef Processors at that time. So I've been in a lot of slaughterhouses, seen a lot of people working in them, and consequently, you don't have to get into the gory details of how it works at its morale plant, I guess, which we call Kraft now, because I know what that's all about. However, it's a very interesting complication when the collective bargaining agreement and the rules of the FLSA come into conflict. So I'll be interested to hear your oral arguments. I have reviewed the papers, and we'll start on behalf of Kraft.
Thank you, Your Honor. I think it's important to first note that the parties appear to agree that there is no Iowa law that is different than the Fair Labor Standards Act. So
Do you concede that?
We do, Your Honor.
All right, thank you. So we're talking federal law.
only the Fair Labor Standards Act. I think we can also agree that one of the courts to have addressed the Iowa law and federal law and donning and doffing and walking time issues out of Iowa is the Geenan case out of the northern.
Judge Bennett,
That's correct.
I'm familiar with it.
And that case was not appealed to the Eighth Circuit. I think it's also important to
I don't know that that strengthens or weakens it.
I'm not sure either.
I presume it was resolved by some kind of settlement after the decision by Judge Bennett, but continue.
Okay. Thank
I'm
you.
not going to speculate about that.
Neither shall I. I think it's also important to start out that we note that the burden of proof in this case and the burden of proof in this motion is on the plaintiffs. There is typically an understanding that...
I guess that's not conceded, but go ahead. I'll hear your argument on that.
Sure. Under the Fair Labor Standards Act, there are exemptions and then there is the law. With respect to exemptions, they fall within Section 213 of the Act. Those exemptions require the employer to produce, by a preponderance of the evidence, information to show that the exemptions apply. With respect to the application of the law, the burden of persuasion always remains with the plaintiff to establish that they have not been properly compensated or that the work performed was work that is compensable under the Fair Labor Standards Act. There was quite a dispute amongst the, well, let me change that. Not quite a dispute, there was a minor dispute, let's say, between the Federal Circuit courts on this burden of proof and the burden of persuasion. And one court, one Federal Circuit court, simply, the Ninth Circuit, in the Alvarez case, which preceded the Supreme Court's review of that case, had suggested that Section 2030 is synonymous with an exemption and therefore must be narrowly construed and the burden of proof remain upon the defendant. Every other Federal Circuit court to address this issue has ruled or held that the Ninth Circuit was incorrect. The Federal Circuits out of the 7th, 4th, 10th, 5th, 11th have all said that the Section 2030 falls within the definitional sections of the Fair Labor Standards Act, and as such, it is not an exemption and is not to be read narrowly. Rather, what the court must do in deciding a case that involves a Section 2030 claim
falls within.
Look at the purpose of that section, and we'll suggest that the purpose is very well articulated by the congressman who had proposed that section, Congressman Herter. Congressman Herter pointed out during discussion about the purpose of...
Spell the name of the congressman for the reporter.
Sure, it's Herter, if I'm not mistaken. That's correct, thanks. And the purpose was created to give respect to the collective bargaining agreements that you started out by discussing at the commencement of this hearing. In fact, what Congressman Herter said is that in the bakery industry, the same industry to which you had referred earlier, for instance, which is 75% organized, there are collective bargaining agreements with various unions in different sections of the country which define exactly what is to constitute a working day and what is not to constitute a working day. I would suggest to the court that that is exactly what is at issue here. What constitutes the working day for which the employees at Kraft's Oscar Mayer facility here in Davenport are to be compensated for? In order to get to that, again, coming back to our burden of proof, there are really two issues before this court. The first is whether the articles are in fact clothes within the meaning of section 2030. The articles are found in docket number 86-2 at paragraph 14. Specifically, there are photographs found at that portion of the docket which illustrate exactly the articles of which we speak during this hearing. And as you will be able to tell, there is very little, or should be very little, debate whether or not these are articles which constitute clothing under section 2030. In fact, every case that has ever addressed, or that, not ever, every case that has been addressed to this issue has routinely come back and said that these type of articles are clothing within section 2030. The exception, noted by the plaintiffs in their briefing, are a couple of district court decisions, one of which was overturned, and
Well, I think that's enough to prove to you that this technology works. And we can fast forward to another voice if you like, and we'll do that right now. Let's find out here. Yes, we do. Let's see here. We got, I'm going to just finish him off here. We're getting to somebody else. Okay, here we go.
Crab's 2030. I think he said a loser was his expression.
That's the way he talks.
That phrase, and the court will have a chance to take a look at it, is the extent to which the Seventh Circuit ruled on that issue against the plaintiffs in that, by calling our claim a loser in that case. There was no analysis. And importantly, there was no discussion at that time about the distinction between the time it took the employees to change clothes and the time it took them to walk from the clothes changing area to their workstations. That's the key issue before the court today. The clothes changing issue is also before the court. Quite frankly, that's a tougher one for the plaintiffs. Mr. Kaplan correctly cites many opinions in which similar items of clothing have been deemed clothes. We will tell the court in a few minutes, or I will tell the court in a few minutes, why we think this case is different. Why we've presented an argument that the court should consider separately. But let me just start, having digressed to the Spurley case and Judge Crabb, with a first point, and that is that this motion is brought. It's a partial motion for summary judgment, and it was brought at the instance of Crabb and with acquiescence by plaintiffs and approved by order of the court, to address exclusively the impact of the FLSA 2030 provision on the donning, doffing, and walking in this case. There are other issues that arise from the donning, doffing, and walking, and one of the issues is whether any of those activities is work. And what that means under the statute is whether any of those issues is a principal activity of work, which the cases define as an activity that is integral and indispensable to a principal activity of work. I think it's Steiner, but I know it's the Supreme Court. Maybe Alvarez and Steiner both say that any activity that is integral and indispensable to a principal activity of work is itself work and, under ordinary circumstances, compensable. This question of whether either the donning and doffing or the walking is a...
All right, I think I'm going to pause it there so that you now know that you can do this without the necessity of using standard typing, which takes forever, but that has been the standard for over 200 years, working on an Underwood old typewriter, that clunker. And no conventional typist, as you can appreciate, can do a rough draft. And even accomplished, not top flight, but accomplished steno reporters who've done their jobs exemplary for many, many years, for many decades. They can't do real time. It's only the top 10%, 15% of all steno shorthand reporters, machine shorthand reporters, who can do real time and do incredible rough draft capability. And yes, of course, their transcripts are formatted. There is Q&A and there is punctuation. We're not there yet but artificial intelligence no doubt will come in at some point and figure those things out, as well as using smart microphones that might be programmable someday soon, so that as one person speaks against someone else using individual microphones and not the same microphone, that microphone could be assigned to that person's name or to a Q or an A for question and answer session. But when we can take this transcript here and send it to you as an ASCII file or as a Word file, and of course preferably synchronized for very cheaply for same-day turnaround, and the original can be shared between and amongst all of the parties, it gets down to a point where it's so ridiculous that even the pauper, the proverbial pauper, can afford to order a transcript, or it certainly is much easier on the budget of the public defender system, or those who are advancing funds to civil litigants who don't have the money to prosecute or defend claims. So this is hopefully going to invite you to give us a call, and we'll be glad to discuss business with you. Thank you very much.